So today's topic, the revocable living trust versus the last will and testament. You know, as we were putting this together, my youngest child and I are seeing all the commercials for King Kong versus Godzilla and the verses, right? So what we're going to do today is, it may not be as big or monumental for some as that, especially for my daughter. And we did see it 2 weeks ago and we enjoyed it. But be sure, just like those movies, there's going to be sequels, there's going to be other issues, there's going to be things that pop up. So I'm sure we will revisit this very important topic as time goes by. As far as our other topics, our other webinars, if you haven't seen them, if you haven't joined us before, if it's your first time, welcome. We do try to do these several times a month. And in fact, come May, we'll actually be doing events every Wednesday afternoon. And that should be the plan moving forward. It's important to get this information out there so that we can try to help you make the right decisions and get the work done so that you don't have to worry about it anymore or keep it in the back of your head. But for prior webinars, and we've been doing these for nearly a year, actually it's been a year ever since the pandemic began, our website has all of the prior webinars, and probably once a week I'll get an email from through the website asking if we have the webinars listed. And actually, if you go to tullyelderlaw.com, under the navigation bar by videos and click on webinars, that's where you can see all the prior topics. We've spoken about Medicaid and the changes going on there. We've spoken about trusts, both revocable, irrevocable, planning in general, elder care concerns. So a lot of information is on the website, okay? Now, for where we are today, I do have the screen shared here, and let me get moving with our topic. Also, if you have questions please feel free to put it in the chat box or the Q&A. I will definitely check those as we wrap up towards the end. So here we go. When we're talking about trusts and wills, what we are dealing with is the concept of estate planning, all right? And estate planning is a lot of different things to different people, but for the purposes of today, there are different parts to estate planning, primarily inheritances, incapacity concerns, planning for incapacity, if you will, dealing with taxation, could be gift, estate, income, capital gains, different tax issues certainly play a role within estate planning. The idea of asset protection, perhaps for the next point there, long-term care. There's a lot that goes into planning your estate, and depending on age and health and finances and circumstances, that's the type of plan you should have in place at that point in time in your life, okay? Again, for purposes of today, we're going to be focusing on two primary concerns: inheritance issues and capacity. Not much detail on capacity, but you'll know what I mean when we get there. Primarily, though, when people think of a will or a trust, they're considering, where do my assets go when I pass away? And that primarily is why we're here, to talk about inheritance issues. So let's kind of define what we're talking about. What is a trust? What is a will? First of all, the trust. So a trust itself, and I'm sure most of you or some of you have seen this in your own life or in your current planning, a trust is nothing to be intimidated by. It is a written agreement, all right? It is a management agreement, if you will, broken down into 3 segments. The first segment is, okay, while I'm alive and healthy, my assets owned by this trust will be managed this way. The second segment is, while I'm alive, but perhaps not healthy, incapacitated mentally and or physically, then this is how the assets in my trust will be managed. And ultimately and finally, the third segment of a trust will detail, when I'm gone, what happens to my assets? Where do they go? How do they get there? When do they get there? Who inherits, who doesn't, etc. So that's primarily, in its simplest terms, what a trust deals with. Now, a trust itself is effective as soon as the grantor creator, and I'll talk about that in a minute, and the trustee sign it. It's effective, all right? And a good point is that it continues even after the client, even after you pass on. It is a continuous document during life, most of the time, and then at death. There are 4 points to a trust document. okay? I mentioned one briefly just a moment ago, the idea of a grantor. So what is a grantor? That is the client. That's you. That is the person setting up the trust. And where it comes from is you're granting it, you're creating it, okay? So you are the grantor, and that's required whenever you have a trust. The second required part is what's called the trustee. The trustee, in the simplest terms, is a manager. That is the person that is managing the assets that are owned by the trust. In some circumstances, the grantor and the trustee is in fact the same person. Where does that happen? In today's topic. In the revocable trust scenario, the grantor and the trustee are the same exact person. The revocable trust is merely a transparent entity that can own your assets, manage your assets, consolidate your assets. In an irrevocable trust, there is a separate person as the acting trustee. We do irrevocable trusts every day of the week. And in that scenario, we're looking typically at a long-term care concern down the road. We are planning for care down the road by utilizing an irrevocable asset protection trust. In that scenario, we typically have a child, or if there's no children, then a neighbor or a sibling, somebody that's trusted, serving as an independent, if you will, trustee for that irrevocable trust. Okay. Now, the third part that's required in a trust is a beneficiary. Now, there can be different types of beneficiaries. You can have a lifetime beneficiary, meaning who benefits from the trust during the grantor's life. You can have what they sometimes call a death beneficiary, meaning who gets it after the grantor passes away. You can have a beneficiary of income interests. You can have a beneficiary of principal, what's inside the trust. So there's different types of beneficiaries built into the different types of trusts, okay? Now, in order to make the actual trust effective, you actually have to put something in it, all right? At the end of every trust document, there should be what's called a Schedule A. That is an informal inventory, if you will. When we do it, and most attorneys, they'll put in the symbolic $10, just so that there is a corpus there, which is a legal term saying that there's something inside the trust to be managed that formalizes the agreement, okay? If the trust goes unfunded, meaning there's nothing in it, it's really not benefiting anybody. So funding the trust is a huge part of actually utilizing a trust, whether revocable or irrevocable, properly, okay? And your attorney should be helping you with those issues when you're first setting it up, when you're first talking about it, when you're first setting it up, and then as it continues on, okay? Now, you've heard me say there's two types of trusts thus far. So let's break that down briefly. There is a revocable trust, and then there is an irrevocable trust. There are two reasons that people do trusts, all right? So I use this little graph here on the screen just to kind of share the different types of trusts, two types of trusts, and the two reasons trusts are ultimately implemented. So we have a revocable, we have an irrevocable. The first reason that trusts are generally implemented is to avoid probate, which is the court proceeding when somebody passes on. I'll get into that in a little bit. The second reason that people utilize trusts is for asset protection, okay? Now, a revocable trust, what does that give me? Well, a revocable trust, if it's done properly and funded properly, will avoid probate, which again is that court proceeding. That's a good thing. That is a great thing, actually. Now, the irrevocable trust, because it is by nature a trust, and it does by nature and funding actually own certain assets, it also will avoid probate for the assets within it. Both very positive, good things. Now, the idea of asset protection, that is a unique scenario. That is something that is very beneficial and done intentionally. It requires an irrevocable trust. It requires certain control to be vested more in the trustee than the actual grantor. Not a lot. When we do irrevocable trusts, there is a tremendous amount of control kept by the client. There is a tremendous amount of flexibility kept by the client. But there does need to be a little bit of a line in the sand there so that we can gain that asset protection. If you want to know more about irrevocable trusts, go back to past webinars on our website or keep getting our emails, get on our list, and then the next time we go around on the irrevocable trusts, you can catch it live and ask questions. Now, The revocable trust, does that actually provide asset protection? The answer is going to be no. And the reason is primarily what I mentioned a few moments ago. When you have a grantor or creator of a revocable trust, they're also the trustee. That's a lot of control and, most importantly, access. And when you have access to unfettered access to what's inside the trust, you're not going to have asset protection. Okay. So the revocable trust, brilliant tool to avoid probate, but not so much at all when it comes to asset protection. The irrevocable trust may be appropriate depending on age, health, assets, because it does avoid probate, but it also shelters your assets within, potentially from Medicaid issues down the road, okay? That irrevocable trust needs to get done in advance of needing the care, primarily. The revocable trust can be done at any point in time. So that covers a bit of an introduction as to a trust. And again, primarily today is about the revocable. Now, what exactly is a will? And it's interesting. The will has to be the number one most identifiable tool or document that folks think about when they talk about planning. I'm not going to say it's every day, but several times a week, we'll have a client call up and say, or a potential client call up and say, I need a will. And that's fine. That is the door opening. That is the initial thought to think, I finally have to get my affairs in order. Planning, whether it's estate planning or asset protection planning, has a lot more to it than just the will. But again, the will is what gets people thinking, gets people to implement a plan. So it is a critically important document. So what is it? Just like a trust, it is a written document. It will distribute, after you pass on, asterisk, it will distribute solely owned property, bank accounts, investments, cars, real estate, after you pass away. Notice solely owned is in italics. It only applies to solely owned property, okay? Now, here's the kicker. It is not effective. A will is not effective. It is not even considered a valid will until it goes through probate, until the surrogate judge in Jamaica, Queens, or Manhattan, or Mineola, or Riverhead consents to that will being admitted to probate. So what is probate? Because the will doesn't do anything for you unless this happens. So what's probate? Well, by definition, when somebody passes away and they have a last will and testament and they have something in their name solely, okay, in my opinion, it's a mistake, but it happens every single day of the week. When there is a will, it is called a probate proceeding, when we have to go to court to get the judge to approve the will. It's called probate. When there is no will, if a person passes on with solely owned assets and no will at all, we still have to do a court proceeding. It is very similar to probate, but it is called an administration proceeding, okay? So when there's no will, administration. So this is, I've used this word momentarily ago, validity proceeding. A probate proceeding, the reason a judge has to get involved is to ensure that that will is the valid last will and testament of the decedent, or the testator as they're called. The validity proceeding is not overnight. It is not check the box. It is not rubber stamp. It is legit, all right? And I'll get into the reasons why and how. But it is a process that's been around for centuries to ensure that the testator's wishes are being met and followed. It is very important that if a probate proceeding is required, that this gets done properly. So I don't fault the process because it's necessary. There have been times when a will has been modified illegally or improperly, or it's been signed improperly, or there was undue influence by a beneficiary or duress placed on the testator, or perhaps no legal capacity to sign. So the purpose of a probate proceeding is to ensure the will was signed properly, that the testator who did sign it knew what they were doing, had the proper testamentary capacity to actually execute a last will and testament. So the proceeding is necessary, but if you have a will and you have solely owned property, but avoiding it all, that's the plan. That's what today's about. Now, One of the reasons that you want to avoid probate, and I'll get more into it, is the idea of what's called a distributee, okay? Distribute with an extra E at the end. That is the family, okay? Those are the heirs, the next of kin, if you will. If we have a father pass away, the distributees are going to be the spouse and the children. If we have a single parent pass away, the distributees are going to be the children. If there's no children and there's no spouse, the distributees are going to be the parents. If the parents aren't around, then we got to start looking at siblings of the decedent, okay? So you always have to find the next of kin in order for a probate proceeding to advance. And if you can't find them, that's when it gets ugly, and I'll talk about, or it doesn't have to be ugly, but it can get ugly as far as time and cost and searching for heirs, and I'll get into that briefly. Now, the process itself, it's just to outline, once the will goes through the probate proceeding and it is admitted to probate, there is an executor appointed. That executor has a fiduciary responsibility to marshal the assets, collect the assets, to pay any creditors, then distribute the assets pursuant to the will, and then close the estate. Okay, and they are responsible to the court during that whole process. Now, why should we avoid probate? Okay, after all, I just said it's good that it happens. It does cross the T's and dot the I's. It makes sure that the will was proper and the intentions of the testator are being met. These are the reasons why I still think probate should be avoided. Okay, and I think we got 12 of them. Number one, time delays. A probate proceeding can be anywhere from 5 months to years, 2, 3, 4 years long. Okay, once the court gets involved, it is their timetable primarily. If all is in order, will is proper, family gets along, family consents, you're still looking at generally a 7-month window before assets are supposed to be distributed to the heirs. Okay, so you have a time delay when you have to probate the will or go to court with an administration proceeding because there was no will. Then you have court costs. The second reason to avoid probate is there are court filing fees. The maximum filing fee is $1,250. You could also have bonding costs. If an executor or administrator is petitioning the court to be named executor or administrator, the court may say, I want you to go purchase basically an insurance policy, a bond, to ensure you're going to do your job. And if you misplace or misuse the assets entrusted to you through the estate, then this bond will give restitution to the heirs. Doesn't always happen, but it does happen more so in administration proceedings than in probate proceedings, okay? But between the court costs and the potential for bond costs, why not just avoid the probate courts altogether? Legal fees. There will always be some type of legal fee to wrap up a person's affairs. But in a probate proceeding or administration proceeding, of course, the fees will certainly be larger, okay? The fees can be billed hourly. Sometimes they're flat fees, but not usually. We used to do that, but not anymore. Sometimes attorneys use percentages, but they're not supposed to. So hourly fees, and lawyers are known for that, unfortunately, that they think the bills are never going to end. And in some circumstances, if you have children fighting or beneficiaries under a will fighting, they may never end. It can go on and on. So legal fees are unfortunately something that is built into the system, okay? Now, privacy. This is one of the most important, to me, one of the most important reasons to stay out of the courts for probate or administration. It is purely public. There is no privacy whatsoever. When we have a child of a recently deceased parent come in and meet with us, and we're engaged, we have to put together a probate petition. That probate petition will state mom or dad's information, the children's information, addresses. If they're under a certain age, they go into if they're a minor, they go into a certain category. If they're disabled, they go into a certain category. It has debts. It has approximate assets listed. And what you're looking at there is basically a snapshot of the family, and that is public. In this day and age of identity theft and fraud and data mining, why put all that information out there? Okay, why? You want to avoid that if you can. I mentioned minors here on the PowerPoint because if you have a minor child or a disabled child or beneficiary, they're listed there. Are they vulnerable? Who's looking at this information? Why take the chance, right? You want to keep things private, okay? Shutdown. So that's 2020. Last year, because of the pandemic, of course, all of the courts shut down for at least 4 months. I don't believe they're still at full staff. They are doing well. They are processing, but there's still a backlog. Think about it. And you don't ever want that to happen to you or to your family. So again, try to avoid the process. Locating heirs. This is that distributees I mentioned on the prior slides. When a person passes on, the family needs to be, the court needs to be sure that those people listed are it, okay? So sometimes the court will require a family tree to explain, to be signed off on, or the next step is they require what's called an affidavit of heirship by somebody that knew the decedent to say there were only 4 kids, there weren't 5. Or we even may have to pursue what's called due diligence. And that's where the court says, we want you to find heirs, or if there's no children, the court needs to ensure that. We know what things happen with families, and sometimes there may have been a child that was not identified with that person, but is a biological heir, perhaps. So this concept of due diligence can be simply, post office records, phone book records, internet searches, or it can be as extreme as hiring a genealogical company to track people down, hiring private investigators. In this office alone, we have 3 estates that have gone on for more than 4 years. The court keeps asking for further people. We have genealogical companies that are following directions from the court through us. And we found one person, then you find another person, then you get it back to the court. Then they come back and say, listen, who's this person? Who's that person? And it just keeps going and going and going. Years through Ireland, through Europe, through Czechoslovakia, the clients we've had through the years have distributees in these countries. And the court requires that in order for the will to be admitted to probate. Now, what if the will says, I leave everything to my 2 children, not my 3rd child? That 3rd child, even though they're disinherited, still has to sign off, okay? So that is something that can cause tremendous delays, and that's the idea of a contest, all right? So a potential estate contest or litigation is a very valid reason all on its own to avoid the courts and avoid probate. So to follow through on that example I was just giving you, if you have 3 kids and you're disinheriting one, that child, do you think they're going to come into court and say, okay, judge, I'm here. I consent to that will being admitted to probate. I agree to my other 2 inheriting everything. I agree to being disinherited. No, they're not going to agree to that so easily, all right? In addition, and just to generalize, if there is a disinheritance occurring, why? Because they were estranged, they couldn't be located, they're in another part of the world, they have addiction issues, they have they're incarcerated. There's any number of reasons why a child can be disinherited. And again, the court will require that child to be found, or at least the due diligence efforts to find them. That is probate, okay? So if there's any disinheritance issues or any heirs that can't be found, it's a really, no offense, it's a no-brainer. You must avoid probate, okay? Now, loss of control. What do I mean by that? So once the court gets involved, that judge is in charge, okay? And the clerks that work under him and call the ones that help call the shots. 2 specific examples. If there is a minor child, or if there is an individual that is disabled and unable to make decisions, so disabled but without capacity, the court will require that a guardian ad litem, old Latin phrase, it kind of means guardian for a short period of time, to step in and represent that minor child and represent that disabled person to ensure they are getting their fair share and to make sure they are being represented in the court's eyes. They don't take older siblings or even other parents, their word for it, that everything will be taken care of. So the appointment of a guardian ad litem, which is typically another attorney, and guess what? They are charging hourly for their work. They will conduct an investigation. And as long as their ward, their minor child or the disabled beneficiary is being treated fairly, then things will move along. But you just added thousands of dollars in fees, and you just added months of time. So the idea of control and keeping things private, again, you're not going to get that in probate. You're not going to get that with a last will and testament, okay? Real estate outside of New York. Wherever there is real estate that the decedent owned in their name solely, probate is required, okay? It may be a full probate proceeding, or it may be what's called an ancillary proceeding. So if a person passes away with beneficiaries and joint accounts, but they have land in New Mexico, and I've seen it happen, tumbleweeds and all, New York probate, New Mexico probate, okay? Again, can be avoided if we have a plan in place that does not rely on the last will and testament, okay? So anytime there's real estate outside of New York, a trust should be utilized, revocable or irrevocable, so that we're not relying on the will, therefore we're not relying on two probate proceedings, okay? Again, any questions about this, just get it into the chat or the Q&A. Liability for the executor, this is legit. An executor, once appointed by the court, is personally liable for any types of debts that the decedent owned if they are not paid off. So if an executor knew there was an $8,000 credit card bill and they distribute all the assets to the beneficiaries anyway, that executor can be personally liable for that $8,000. It can get ugly. Personally, I've never seen it happen because, you know, as attorneys are involved, they make sure the bills are paid, the creditors are paid. But it's out there. It's a risk. So why take that chance? The idea of estate recovery. So in New York, we have a difficult but valuable Medicaid program for home care issues and nursing home issues to pay for a person's long-term care. Medicaid has a claim against any assets that go through the person's estate, okay? And when we have an account that is in a person's name alone, that's on Medicaid, they pass away, that account has to go through probate. If there's a will or not a will, still has to go through probate. And guess what? Medicaid is a creditor, so they will get paid back. So estate recovery of assets of the Medicaid recipient will be lost because New York state law says New York state Medicaid can go after those assets in that person's name alone. All right. If it's joint or in a trust or beneficiary, no, they can't touch it because those assets are not a part of the estate as per New York law. All right. And finally, with all these 11 things going on, the idea of stress. And this I've seen personally, this we've seen with dozens and dozens of clients. It's a stressful proceeding. So why not, again, just avoid it? You can, okay? So why should I have a revocable trust? Why should I have a trust? Why should I avoid probate, okay? And let's go through some points. A revocable trust for the assets owned by the trust, avoid probate. Okay, that trust is the actual owner of the asset. That trust will say, like I said in the very beginning, do this with my property while I'm alive and healthy. Do this with my property while I am alive and perhaps no capacity. And finally, do this with my property when I'm gone. So that trustee owns the asset, and that trustee can distribute the asset even after the person passes away without any probate proceeding, without a court proceeding, okay? But it only works if the asset is owned by the trust. Secondly, maintains privacy. You're not going to court. You're not doing a probate petition. There's no data mining. There's no identity theft. You're not telling the world who's disabled, who's a minor. It's private, okay? Very valuable reason. Saves time, months, in fact, okay? And if there's a need to pay bills, or if there's a need for access to the funds for a beneficiary through a trust, it happens so much faster, so much easier. We have a client right now that's actually a friend of the family. We tried to do a trust, but clients are in charge, and we do what clients want. All we can do is make our recommendations. We are in the middle of a probate proceeding. There are several children that are not beneficiaries. They are not local. and there are bills piling up. There are several parcels of land that have real estate taxes, that have utilities, and there's no access to money because it is tied up in the estate waiting for the will to be admitted to probate. The stress that that one child is going through is ridiculous. So there's no access to money. We're waiting and waiting. Just avoid probate so there's access, okay? Don't rely on the will for your personal plan. Minimizes litigation by heirs. So what I mean by that is dovetailing on what we said earlier. If you have three children and one is disinherited and you're going to probate, that disinherited child has to sign off. But you know what? If you avoid probate, if you have a revocable trust in place, the trustee can distribute the assets. There's still a process. There's still an internal family process that we have to be involved in to close the trust, to protect the trustee. That would be the client. But it's a heck of a lot faster. It's a heck of a lot less expensive. And we don't have to talk to the child that's disinherited. We don't have to notify them. We don't have to mail them anything. Okay. So it minimizes that. Now, can that disinherited child go to court and hire a lawyer and try to bring a court proceeding? They can, but are they going to do that? Okay. That's the point. The revocable trust minimizes all of those risks and in most cases eliminates them. Ancillary probate in other states. Again, if you have real estate, New Mexico, Florida, Arizona, the Carolinas, wherever you have real estate, they need to be set up so you are avoiding probate, okay? In your revocable trust or in an irrevocable trust, or at least the idea of joint ownership. I'll get into that in just a moment. It works for the time being, but it's not the best answer. No probate fees, no court fees, no bonding. That's why I should have a revocable trust. Not required to locate missing heirs. I just spoke about that. It's faster and you're not paying genealogical companies thousands and thousands of dollars to go find people that may not exist. No court control. You're not talking to the court. There's no attorney being appointed as a guardian ad litem for minors or disabled folks. This is crucial. This is what I was getting at earlier, talking about incapacity as far as today. When you have an investment account or a bank account within your revocable trust, okay, you are trustee. If capacity is lost, God forbid, stroke, illness, accident, or even pass away, the document clearly states there is a successor trustee that steps up. That successor trustee is more easily acceptable to the financial institution. If there is no revocable trust owning these accounts and capacity is lost, then the power of attorney agent, hopefully it's done right, hopefully it's done, period, hopefully it's done right, and hopefully the power of attorney agent has access, they then take that original power of attorney and have to go to the financial institution. It then has to get approved by the legal department in Kalamazoo. It can take days, all right? And they may not accept it. We've seen it 100 times. We will, if it's our power of attorney or our client, we will try to get it accepted. We'll go up the chain if we have to. But again, why go through all that? Okay, if you can avoid it, you do. Now, with all this said, folks, a revocable trust isn't for everybody. Some clients we talk to, they don't want it. They just want the simple will. That's all they're focused on, and that's what they're going to get. Or other circumstances don't call for it. Okay, so it is an increased level, an increased technique when it comes to estate planning. It's not for everybody, but it is for most people. Minimizes estate recovery. And in fact, the example I gave, it would eliminate it altogether in that situation, okay? So you don't have to worry about Medicaid going after the estate because there will be no estate because the revocable trust will own the assets, okay? Now, let me kind of summarize a bit. When a person passes away, all right, that's what we've been talking about. How are your assets going to be distributed? Is it going to be distributed through the last will and testament, or is it going to be distributed through the revocable trust for the purposes of avoiding probate? There are other ways to avoid probate, okay? So in essence, and basically a summary of what we just covered, there are 5 ways in which somebody can own something when they pass on, all right? During their lifetime and then when they're gone. They can have something that's solely owned. That means the courts, right? If there's a will, it's probate. If there's no will, it's called an administration proceeding. They can own something a joint account with survivorship, perhaps with a spouse or with a child. That means one of those owners pass, the other one gets it automatically. No courts, no probate. You can have a beneficiary on an account, like a life insurance policy or an IRA or an annuity. Verify you have your beneficiaries done. Once the person passes on, the beneficiary fills out a claim form, they get the account, avoids probate, okay? Then you can have the revocable trust, whatever it owns will avoid probate. Then you can have the irrevocable trust, and whatever that owns will avoid probate, okay? Now, how do we do all this? And this is important. It dovetails very nicely into what we've been talking about. So for some folks, we will put together what's called a probate estate plan. And that will be a last will and testament. That'll be a very comprehensive, durable, modified power of attorney, which is all the financial and legal decisions. It'll be the healthcare proxy and the living will, which is the end of life document. That is a basically a probate estate plan. Then there is the idea of a probate avoidance estate plan. That is where we're going to do all the documents we just did. What's called a pour over will. It's still a will, but that is the complementary will for a revocable trust plan. In essence, we have to do this. We want to do this because if there is an asset that the client forgets that is in their name alone, either they forgot it when they met with us, they forgot to put it in the trust, or they inherited or acquired it after the trust was done and they never put it in the trust, then a probate proceeding will be required for that one asset. That will that'll be used is called a pour over will. In essence, through probate, and yes, all the requirements I mentioned earlier still have to happen, but that will scoop up that one asset and pour it over to the revocable trust. That's where it has its name, okay? So in a probate avoidance plan, we're still doing a will, but it's a pour over, still doing the solid power of attorney, the healthcare proxy, the living will, but we're doing a revocable living trust. This type of plan is typically for those under 60, 65 years of age, okay, with assets that we need to protect and avoid from probate, okay? Again, revocable trust is an asset protection, but it does, again, protect against probate. And a revocable trust is very easily used for folks over 65 years of age. It's just because it doesn't offer asset protection, this plan is the better plan for folks that are in their 60s and should be thinking about potential long-term care. That type of plan is of course, the will, the power of attorney, the healthcare proxy, the living will, and an irrevocable asset protection trust. Yes, you could also have a revocable, and we've done that for many families to avoid probate for those assets. So the irrevocable trust shelters and protects. The revocable trust still have access. You still spend that money, and it'll avoid probate when you're gone. Doesn't protect it, but they can work together as a part of a greater plan. This elder care protection plan is the most comprehensive service that I'm aware of for folks in their 60s looking to protect their assets. When we do that for a family, we come on board for a year. Any questions, any issues, any changes, family meetings, all included for that year. It's all about helping the family communicate. It's all about helping the family prepare for care down the road. And it's all about avoiding a crisis, okay? So that's the plan when we don't have greater care needs. When there are greater care needs, then we're talking about our signature service, if you will. This is what people call us for. This is why clients reach out to us. This is why home care agencies, social workers at hospitals reach out to us. We are the only law firm that provides a life care planning service where we will do the estate planning, the asset protection, the income protection, the Medicaid work, and the care coordination and advocacy. This plan is literally all hands on deck. The attorneys handle the Medicaid work, the protection work, and my geriatric social workers, what we call elder care coordinators, are going to be there to assist the family, support the parent, the elder, and support the caregivers, all right? And while a little plug here, next Wednesday, I am doing another webinar that you can register for where we're going to be talking specifically about this advocacy work. So for yourself or your coworkers, your friends, your parents, if there are any care issues or you're approaching that realm, Julie Ulrich is one of our care coordinators, and we'll be talking about the attorneys and the advocates working together in a life care plan scenario, all right? So again, the life care plan is only for those that are approaching the care needs, all right? And it's a great way to cover all of the services and really help the family during their aging journey. Okay, thank you. There is the information if you need to talk to me, if you need to set up a time to talk about an estate plan for yourself, a probate avoidance plan, an elder care asset protection plan, or a life care plan. You can email me directly, Brian, B-R-I-A-N, at tullyeelderlaw.com, TULLYELDERLAW.com, or call the office, 631-424-2800, 424-2800. Let us know if you see our car on the road. All right, we're doing that. We have our Tully mobile driving around the LIE, driving around Long Island. Let us know if you see that on the road. Facebook, Instagram, also another way to find us. Let me see. We do have some questions. All right, what do we got here? First question, and if you have questions, please go to the chat box and get them in there. Can there be more than one trustee? And the answer is yes. You don't want more than two generally. You can always do more. It's almost, too many cooks in the kitchen, that type of a scenario. So if you have one trusted child or relative, that's the one you go with. I don't like the idea of just naming people so everybody's involved. These are business decisions. These are people that will be helping you with finances, etc. So you want the right person, all right? You don't want to pick somebody just because they're going to get offended, all right? So we can talk more about that. Will you have asset protection in a revocable trust if the grantor is not the trustee? And the answer is no. The reason you do have asset protection in an irrevocable trust is because the principal, the money in the trust, is not available directly for the grantor. In an irrevocable trust, we have to build a wall between the client and the assets in the trust because it's all about access. And if you need access, and that's what it's all about, then the revocable trust is the only answer. But the more I share with clients about this irrevocable asset protection trust and the fact that there is a lot of control and a lot of flexibility, even though you're not the trustee, and even though you can't get a direct check from the trust, it is the right tool for so many people, all right? When is somebody married, is the spouse the automatic beneficiary, or could the grantor make the children the beneficiary? Good question. Depends on the type of asset, interestingly. If a husband and wife purchase real estate, then that's automatically survivorship. So in essence, that's a beneficiary. But if it is a bank account that own in your name, or an IRA you have in your name, they are not automatically a beneficiary at all. You literally have to make them joint on the account, or make them the beneficiary, or put them in the trust so that they inherit it without the courts. The grantor can make the children the beneficiary instead of the spouse. Gets into a whole nother issue of what's called a right of election if the client is minimizing or disinheriting the spouse themselves. So there's a red flag there, but yes, you can generally name children directly. If each spouse puts 50-50 of the assets into a joint living trust, which, by the way, we don't do because of your question. The issue is if there's a joint revocable trust and one of the spouses pass away, you're looking at irrevocability, and therefore it limits the surviving spouse's ability to revoke if they have to, or different access issues. We always do one revocable trust for each spouse, so husband, wife, etc. One revocable trust each. Reason being is they have full access even if the spouse passes first. So, and think about this: if it's a revocable trust, it's revocable because the client, the grantor, is still alive and able to revoke it. But the moment they pass on, right, you lose that ability to revoke because they can't do it anymore. So we want to avoid that stickiness and that mess. So two revocable trusts shouldn't change the price much for a client, except when you're dealing with spouses, there's other documents that have to be done as well. So it does often have a different price point when you're talking about fees. But I wouldn't do it that way. All right. What are the courts requiring? Why are the courts requiring a person to provide a copy of a living trust when a will is being probated? So sometimes the court will require, if you're going through probate, they'll require a copy of the trust just to establish the whole picture. Okay, so again, another reason to avoid probate. person said they missed the beginning. I'm sorry you missed the beginning, but you can catch the recording on our website, tullyelderlaw.com, under videos, under webinars. It should be up by the end of the day. If the real estate is placed in the trust, do they keep the step up? Great question. When we inherit from our parents, for example, or inherit from siblings, we receive, because it's an inheritance, we receive what's called a step up in the basis, which means we receive the property at fair market value. We can turn around and sell it without paying capital gains taxes. As long as that is national federal law, then that will exist. Both the revocable trust gives the step up, and the irrevocable trust also gives the step up, as long as it's done properly. Okay, so good. Oh, yes. Thank you, Herbert. Now, let me see. There's people raising their hands, and I don't know how to access that. I apologize. I don't see any other questions here, folks. So I'm going to say thank you. Again, a great pleasure. Please register for next week, and we'll see you then. If there's any questions, please always feel free to reach out. Thank you. Bye-bye.